This week's module reviews legal and ethical foundations of practice. So to start, let's review the ethical principles. The first is beneficence, which refers to doing good with a person's best interests as the ultimate goal of all action. And non-maleficence refers to the idea of doing no harm. Justice is the next principle, which refers to fairness to all and avoidance of favoritism, with the idea that all patients deserve fair access to resources. Fidelity is loyalty to the person, and it is being true to doing what we say we will do. Self-determination or autonomy is a right for a person to determine his or her own fate. And this can be done in a living will or advance directive, where a person is making a decision in advance of a critical situation and determining what options they would like in their care. Full disclosure and veracity refers to providing truthful information. So in order to have true informed consent, that particular individual has to have complete information on all sides of the issue so they can weigh both the advantages and disadvantages of a situation. Privacy refers to the person has a right to determine and control the amount of information to reveal about themselves. And in confidentiality, that information that is revealed is respected and not revealed to others except as part of the professional relationship. And I'm sure you're familiar with this in the idea of the Health Insurance Portability and Accountability Act. So this addresses that idea of privacy and confidentiality. And then the ANA position paper on privacy and confidentiality addresses patient advocacy and trust in the professional relationship. So it includes individually identifiable health information, genetic information, and mental health information as well. So there are systems of ethical decisions, and the first is utilitarianism. So this is focused on the consequence or the outcome with the greatest good for the greatest number is preferred. In deontology, it's based on obligations as rules and unchanging principles. So here, there is a requirement of adherence to a set of established rules, and that decisions have to be made in a consistent manner. So think about, as you see or read about ethical dilemmas, which one of these systems is being used. The ANA Code of Ethics for Nurses was revised in 2015, and it expresses the values, virtues, and obligation that shape, guide, and inform nursing as a profession. Within those, there are provisions and then interpretive statements, which promote understanding for the appropriate application of the Code of Ethics in practice. Within this week's module, I have provided links to the new Code of Ethics, as well as 2 articles that go through each of the provisions and the interpretive statements with examples of how they can be interpreted. And this can be valuable information for you to use as you prepare your ethical dilemma presentation. So in making ethical decisions, there is a process that is described in your textbook, and it talks about first obtaining the background information, looking at the ethical components, so going through and seeing what are the concerns related to ethics, then identifying the ethical agents or persons involved, what options are available, apply the ethical principles, and then make a final resolution or decision. So what is an ethical dilemma? A problem with options that seem equally unfavorable. And you'll be asked in this assignment to go through and describe an ethical dilemma and then apply the process. So ethical dilemmas can revolve around the issues of informed consent, advanced directives, persistent vegetative state, organ procurement and donation. Genomics is getting much more because of what we are able to do now and some decisions that have to be made based on genetics. And then impaired or incompetent colleagues. And these are just a few examples. And I would encourage you to go to those readings to get some more ideas of, with each of those provisions, what a dilemma might be. So as we move into law and ethics are very tightly connected, but let's look at some sources of law to help us determine how that fits. So statutory law is the first, and it is created by legislative bodies. An example is the State Nurse Practice Act, which describes and defines legal boundaries of nursing practice within each state, and it does differ state to state. Then there are regulatory laws, which are decisions made by administrative bodies, such as Board of Nursing Rules and Regulation. So an example can be a requirement to report incompetent or unethical nursing conduct to the State Board of Nursing. And then common law is related to judicial decision made in courts based on individual legal cases. So these can be examples of informed consent, right to refuse treatment, negligence, and malpractice. So if we look at what are the legal implications in nursing practice and statutory law, we think about civil laws, which protect the rights of individuals within society and provide for fair and equitable treatment. So an example civil law violation is negligence or malpractice. The criminal laws protect society as a whole and provide punishment for crimes. They can be either a felony or a misdemeanor. And an example is misuse of a controlled substance. So felonies are serious penalties, can be imprisonment, that can be the consequence of that. Misdemeanors are usually less serious and can require a fine or a prison sentence of less than 1 year. So our standards of care are one of the ways that we're judged in legal practice. So they are legal requirements that describe the minimal acceptable nursing care. They reflect the knowledge and skill ordinarily possessed and used by nurses practicing in the profession, and some sources of this are the ANA standards for nursing practice, which define the role and function of the nurse in practice. The State Board Nurse Practice Act defines the scope of nursing practice and distinguishes between nursing and medical practice and established education and licensure requirements. The Joint Commission requires accredited hospitals to have written nursing policies and procedures. So torts. These are civil wrongs made against a person or property. So intentional torts are willful acts that violate another's rights, and these can be assault, battery, false imprisonment, and false imprisonment can be an issue related to restraints. Then there are quasi-intentional torts, where the intent is lacking, however the violation is the action with a direct cause occurring. So examples are invasion of privacy, defamation of character, or breach of confidentiality. Unintentional torts, and here the nurse's conduct is compared to the standard of care and whether a reasonably prudent person would act under the same consequence. So negligence is action below the standard of care, and malpractice is professional negligence. So one example of an act is the Health Insurance Portability and Accountability Act of 1996, and it speaks to standards and requirements for electronic transmissions. It does look to improve efficiency and effectiveness of healthcare delivery by creating a national framework for health privacy. It protects and enhances the right of consumers by providing access to their health information and controlling inappropriate use of information with the goal of improving quality of care. The Good Samaritan Act is another example, and this act provides and protects you as long as you did not act with gross negligence. You are to provide care consistent with your level of expertise, and once you commit to giving care, you must stay with that individual until transport or emergency medical services arrive. So how can we minimize liability in nursing? We've spoken about the standards of care and looking to make sure that we are maintaining those standards, and there are multiple sources of that. Record keeping is key because it is evidence of care received. There is conversation that rapport with patients can help to minimize that liability, making sure that they feel comfortable with asking you questions and having conversations about their concerns. Addressing patient rights, making sure that there is informed consent, and in this case, making sure patients truly understand what it is they are consenting to. And then malpractice insurance is a way to protect you in case of an event that might be beyond your control. So some common issues in litigation are related to informed consent, patient self-determination and advance directives, and delegation is often an issue. And with delegation, it is important that the nurse ensures that this task should be appropriately delegated. So you need to assess the patient, determine what the competence is of the individual you are looking to delegate to, and delegate only those tasks that delegatee can be expected to perform safely for the patient under existing circumstances. So in order to do that, it is very important that the nurse is aware of the scope and standards of practice of the individual being delegated to. So for this presentation, I use the following references, and I hope this will help you as you prepare for that ethical dilemma presentation. Thank you and have a great day.